Good morning, ladies and gentlemen. I would like to extend a warm welcome to all the attendees who have joined us on the session today. I would like to also thank Arab Security Conference for this opportunity to present amongst the illustrious roster of elite speakers and industry experts. I'm happy to share the podium with them and present my topic to you. Today's topic is safeguarding national interests in the future of cloud computing. My name is Karthik Palani. I work with Crossbow Labs. Crossbow Labs is a cybersecurity consulting company specializing in compliance and regulatory audits. We also provide a slew of support services and implementation services, which cover testing, security monitoring, SOC monitoring, and we also have training purposes covered under our ambit of services. I work as a regional manager for business development and strategy in the MENA region. I have a cumulative 12 years of experience. Now, moving on to the topic, we'll have a brief introduction on what we are planning to cover and what are the points that we are trying to illustrate from this session. We have seen that there is an increased dependence on cloud resources, whether it is store, computer, process capabilities from the cloud storage, for enhancing business models and depending on that as a delivery model for all the key infrastructure services as well. So a lot of data is being collected from the citizens, nationals, and people belonging to a particular country, and this data is of key importance to these government organizations and agencies in order to identify where they can bring upon improvement and also to analyze where they are set in terms of the economic growth and progress. So this data is of key importance, and when this data is stored on the cloud, we often come across a scenario where the control over the data does not always reside with the owner or with the legal jurisdictional bodies which are trying to regulate how the data has to be governed in terms of privacy and security. So that's what we're going to look at, how the countries go about in protecting, safeguarding the national interest, what are the methodology they adopt in order to regulate this data governance, and because of the methodology that they've adopted, what kind of stress does this put on the ecosystem? Now, when we talk about the ecosystem, we are talking about cloud service providers, cloud users, industry practitioners, and service providers who operate and leverage the advantages given by the cloud platform in order to further their business. And what kind of technology challenges does this put on them? And for a small organization or a fledgling startup, does this become a deterrent because of the controls that they will have to take into stock and the compliance that they will have to cover from a legal and a regulatory framework? So we will look at what is the intent behind such an approach, what do countries want to protect and how they go about it. We would also briefly cover what kind of challenges a cloud service provider or a cloud consumer will face such an environment. Then we will see about some of the recommendations that we have in order to bring the compliance and the challenges and have a solution by which the users and the businesses and the countries can work in a synergistic model and leverage the advantages that digitization brings to such a platform. So we will move on to what are the governments and nations trying to protect. As we know, all the data that is endemic to a region which is collected from the citizens, there is a lot of research and development and analysis that happens on this data set. Countries use this to generate insights, whether it is with respect to identifying factors which govern the economic development in a region, or if they want to simply take stock of where or how they have performed over the last year with respect to a policy or factors which govern the social governance as well. So key generation of insights is something that governments depend upon from their analysis of these data sets. And as we know, the data set is something which is sensitive and confidential in nature. It often can lead to identify a citizen personally, this under the category of personally identifiable information, which could be leveraged by malicious individuals or for example, a foreign surveillance to understand how this can be leveraged for their own advantage. So the countries and governments want to protect this to enhance their own development and safeguard their national interests. Some of the applications could range from security or law enforcement, research and development, like we said, to generate insights and identify the factors for economic growth, to identify what are the baseline policies and practices that they want to bring about in order to uplift a community or to develop the growth in a particular segment in a much faster way. Now, having said this, We also know that the information that is collected, we will just briefly understand what kind of information this could be. We've broadly classified this as personally identifiable information, but this could also be uniquely identifiable to an individual with respect to how their financial records are maintained. It could be health information. It could be individual religious sentiments of a community or an individual who is endemic to a region. So all this information is sensitive and come together in order for the governments to identify what are the national interests that this to be protected from. And also this gives the governments and the policy regulators a way to identify the jurisdiction over the data. Many times we see that the data is stored in a different location, and countries will want to retain control and exercise this control when it wants to bring back the data within its control and the logical boundary of its country, and hence they want to have some protection methodology and measures by which they can exercise this jurisdictional control that they want to retain on top of the data set. We have seen some countries, I've just taken a few examples from the MENA region, where the government has gone about putting this information on the cloud, and what they have done is they've also seamlessly integrated their services. This could include key infrastructural services like law enforcement. It could be health information related services. It could be insurance. Any of these infrastructure services, utility services that a government wants to take to its citizens can be seamlessly integrated. The citizens no longer have to visit multiple physical public sector offices in order to reach out for these services or perform the duties and obligations that they respectively have to deliver under the law. So what we have essentially, the governments are doing is they have reduce the effort, and they have a single way to identify how the different communities and citizens within a country utilize these services and also leverage upon these services, and this will be a key factor in order for them to come up with policies, in order for them to estimate how the growth has happened, what are the areas of improvement, and what are the key areas and interests that will have to be protected. So that is a good start with all of these countries where they have brought about digitization, where they could leverage the free flow of data within the country across different verticals, and they can seamlessly integrate the data to analyze how the progress is established and how they should progress to the next step. Now, what are the ways in which a country can establish this control over data privacy and data security? One such measure that most countries have adopted is data localization. Data localization is nothing but any data which is collected or related to a nation's citizen or a resident will have to be stored within the country. Whether they are stored, processed, or collected is defined within the localization policy that is applicable to such data set. This data which the country identifies as critical and wants to retain control over will have to be stored within the boundaries of the country. There are some localization policies which do allow data to be transferred across international borders, provided the local policy regulations are first adhered to, and there is a consent mechanism where you clearly indicate to the citizen or a resident that the data is going to be transferred. So the purpose for which the data is going to be transferred will have to be explained very clearly. A consent will have to be obtained for that, and you will also have to define what is the retention period for which the data is going to be kept in operation for the intended purpose for which the data was collected originally. So this is how data localization policies are generally structured. Each country has its own way how they want to protect this information, what level of control they want to retain, who are the verticals or industries which will be regulated under this data localization policy. This would be defined in the policy set, and countries and legal regulators would hold control over how it is implemented as well. Now, what are the objectives that data localization helps a country or a government organization to achieve? Is they would be able to establish a minimum set of data security and control measures that they would be requesting any service provider or an entity operating on the data set to comply with. They would have a clear understanding of who's the owner of the data, so the accountability will be established, and the data jurisdiction. With data sets being transferred to different countries, there is a loggerhead on which legal and jurisdictional policies would apply and what would govern dispute resolution. With data localization, most countries have established that their own local laws and regulations will hold control over how and this data set should be regulated, who will be the players who will be responsible for it. So these are the objectives of data localization, which helps countries to establish a sense of control and regulate the market in which the data is being pushed across. Now we will look at some of the countries who have already adopted this. A lot of countries have their own data localization policy established in order to regulate this data. Now we will have to keep in mind at this point of time that not all countries look at data localization the same way. They do not look at all the data sets with the objective of governing them. Each country identifies that a particular data set or data belonging to a particular industry will have to be regulated under the data localization policy that they come about. As you can see on the slide, there are a few countries which have gone about and established the data localization policies. We will just take a couple of examples to understand how this goes. For example, India, if you take the data localization policy in India, what they have done is they have specifically identified the payment transaction data as the data set that they want to govern under the data localization. It is regulated by the Reserve Bank of India, which is a central banking authority for the country, which regulates how financial information and transactions are conducted. Now they have identified that the payment card or the payment transaction data is the data set that they want to be protecting, and it is of importance to them, and they want to safeguard this in the interest of national interest. However, there are countries which have gone broader, like in the case of Russia, where Russia has the data localization policy which covers all the personal data which belongs to a Russian citizen. Now they have stated that any information that belongs to a Russian citizen will be stored and processed only within the country. Now why do these countries go about it is we live in an age where they have recognized that data is the new oil or the new wealth. We are not talking about other factors of financial concern. We are talking about data. There is a huge potential for this data to be as a key. It is identified as a key factor which will develop and grow an economy to massive scale. So that is the reason and the intent with which each country operates after identifying which data set is key to their progress and how they want to be protecting it. Now, while we have countries like what you see on the screen who have already gone and implemented data localization to regulate, control and privacy over a lot of these data sets, there are also countries which do not believe in data localization as an effective way because these are countries which believe in data free flow across borders as a way to enhance business and growth. Countries which are, we'll take the example of US, which has some corporate giants like Amazon, Microsoft, Google. So now these are companies which have their own business model across the globe, spread across the globe. There are millions of users from different regions and parts of the world who subscribe to their services and do the daily business operations on their offerings. Now these companies have structured the data to be free flowing and not confined to any particular legal or jurisdictional boundary with which they want to be regulated. So that is the concept that we are going to be looking at. What are the challenges that the countries face in order to regulate the privacy, and what are the challenges that a service provider or a cloud consumer will have to face in with the advent of data localization, and how we can bring these two concepts together through some recommendations to build a sustainable model where the privacy and security which data localization offers, along with the jurisdictional control of course, can be leveraged by a business which operates on a global scale, utilizing the advantages and the flexibility that a cloud platform would offer. So we'll go about that in a sequential basis. The following slide is a brief understanding of some of the examples. We have already discussed a few of them. In 2015 June, Germany wanted to regulate telecommunication related data. So all the companies and ISP providers who were working in Germany were required to store all the information belonging to German citizens within the boundaries of the country. Russia went ahead and implemented a GDPR style law where all the personal data must be stored within the country. India covered payment related data. United Arab Emirates in 2019 decided that healthcare related data cannot be transferred outside of the country. Now, as we can see, different countries have identified the data sets as critical or important depending on what they're trying to propagate and promote within their own growth, and they want a sense of regulations and a set of frameworks to guide and regulate the market in which such a data is being used. Now, we will look at an example where some of the challenges that the diversity of cloud environment can throw to a country or a legal body when it comes to dispute resolution, or we are talking about a lack of or a breach of contract or a denial of service. Let's take the case here. A company is set up in the Middle East. The company A handles some sensitive and confidential information belonging to that citizen of that country. Now, company A does not have any physical or personal infrastructure, so they are hosting their services on the cloud, and they are leveraging the advantages of a hosting location from another country in Asia, for example. Now, if company A wants to bring some charges against a service provider due to either a data breach or a failure of service for that matter, now what are the questions that come to us on such a scenario? We can clearly see that there could be a legal issue as to who or which rules can apply. We can also see, because of the diversity of the environment in which we operate today, there is no legal framework or a judicial authority which can uniformly understand what are the challenges in such a scenario and pass a ruling or come to a resolution in such a scenario. Now, do we take the legal considerations of the country from which the company is operating, or do we have to take the legal regulations from the country where the data is being stored? Now, if we take the case that let's say that UAE courts have been appointed as a neutral body to govern and regulate this dispute resolution. Now, in UAE Civil Code number 5 of 1985, a cloud user will have to demonstrate or prove the value of loss that he has sustained through either damages or from breach of contract. Now, in a distributed model where they are operating in different geographies, the perceived value of data could vary, and also the damages that they've accrued could also vary depending upon the time. So the time extent to which the data is being exposed. So with these 2 points alone, we can see that a cloud user will not be probably able to demonstrate without reasonable doubt as to how much of loss has been perpetuated in this case from either a data breach or from a lack of services from the cloud service provider. Now, even if we take the legal perspective for issue resolution or dispute resolution for a data breach, now again we'll take the example of UAE, where there is a federal law number 2 of 2006 which states that the criminal intent established by a malicious individual through a hacking attack can be clearly demonstrated, and there is way in which it can be addressed. But there is no law which really governs how a service industry will have to be regulated by, especially if the service provider is in a different country. So there are a lot of legal laws and regulations which interject against each other depending on which geography you're looking at from. And not only that, there is no central unified way in which all of this can be established and treated with the idea of issue resolution into picture. This is the reason why most countries would want to retain the jurisdictional control on top of the data set, especially if it is that belonging to a citizen which is of importance to them, which they want to protect and save in order to propagate their own growth. So the advantages of digitization is also a challenge for countries in order to establish their control over the data set. So we will look at some more concerns which revolve around the service providers and the cloud users with the advent of data localization policy into the mix. Now, we are going to be talking about we'll briefly look at how the service providers have architected their solution and their service offerings in the industry. We'll look at how they go about what are the challenges they will face, and we would also look briefly at what kind of challenges or points that a cloud user will have to keep in mind with respect to adherence to data localization, but also to propagate their business. Now, having looked at these two, then we'll move on to some cases and then recommendations on how we can marry both these concepts together in the interest of cloud computing future and for also countries to safeguard their national interests. These are some of the examples of popular cloud providers. This is not an all-encompassing set, just a brief examples which we are all familiar with our daily operations and business models. We have Amazon services, we have Microsoft services and Google Cloud services. Now what they've gone about is they have expanded their services across the globe, identifying key areas from which they are distributedly providing their services. They essentially have a central distribution model in which services from one particular region can cater to a larger chunk of cloud consumers, and they also have a lot of technology offerings. We will have to at this point understand that all technology offerings that the cloud service provider offers may not be available to a cloud consumer in all regions. They have their own way of architecting this, and specific technology offerings would be available in specific regions. There could be a case where a cloud user would want to leverage the hosting services, let's say in UAE, but that technology service may possibly be not available in UAE but could be available in Africa. This is just an example. For the full set of services and regions offered by these providers, we could always look up on their website and understand that. So we will take two business models and see how they are structured. Now, as we take Amazon in this case, Amazon is spread massively and it's offering services across the globe. They cover about 22 geographic regions and 69 availability zones. We'll take a moment to understand what is a region and a availability zone so that we can place the things in context. A region is nothing but a cluster of data centers which is established in a region in order for the service provider to offer services, whether it is cloud, compute, process or storage. Now, this cluster of data centers which is in the region will consist of a subset of availability zones, as you can see in the illustrated diagram in the screen towards us. Availability zone is nothing but an isolated data center which is endemic to a region but separated physically. Either they have their own methods, a few of them are 300 miles or so distributed, in order so that the environmental disturbances will not completely affect the way in which services are being delivered. And the reason why they have multiple availability zones is that business continuity and disaster recovery is taken care of. One unit goes down, the other unit acts as backup and comes up with the services. They also provide high resiliency and availability for data, which is a key factor provided by these services, which is critical for most businesses who operate in a model where data is to be available to them 24/7. There are businesses which could shut down if this information is not available to them for a period of time, or they could suffer massive financial losses if the data becomes inaccessible. So in the Middle East, UAE, in Bahrain, they have set up their geographic region and they have availability zones, 3 availability zones. Now, the number of availability zones depends on how big of a geography they cover and how they have structured it. And a region doesn't mean that they are operating in one country. It could be a cluster of countries to which they're offering services from here. Originally, when this is planned, there is no dependency on which region the cloud consumer is going to be reaching out for these services. You are free to use services from any region and depend upon the cloud service provider for access to the same. So this is how they have architected, and we will also look at one such case with Microsoft. Microsoft also covers about 60 plus regions around the world. Instead of a region and an availability zone, what they have is a region pair. The concept is very similar to what we have seen in the previous slide. The region pair, let's say for in the Middle East, they have UAE North and UAE Central. That's how they have structured. The region 1 and 2 operate in pair. One happens to be the primary, the other happens to be the secondary. Now, if the primary services go down, the secondary will activate and start providing services to all the consumers and acts as a backup to provide business continuity. Similarly, disaster recovery is taken care of, and a lot of region pairs will come together in order for Microsoft to provide their services globally. So from these two examples, we have seen, though there are minor differences in the way the services are architected, a service provider, in order to cater to the needs of customers in one particular market segment and to deliver on their services effectively, will have to do massive infrastructure investments to set up multiple installations from which the services can be requested from, and they will also have to invest heavily in the model in which technology enhancements can be brought into this sector as well. Now we will look at some of the challenges what we are just talking about. Service providers with data localization in mind will face three definite challenges. One is operational, one is legal, and one is financial. Now, as we see, they have a central distribution model. For example, if you take the case of Amazon with the data center region in Bahrain, now they will have to address all the nearby areas by virtue of the services they're offering from that particular data center. Now, if we take the case of UAE, where any service provider who's working in the healthcare industry will want to save his data on the cloud. Now, as the data localization policy states, this information cannot be stored anywhere outside of UAE. So by virtue of this, the consumer will not be able to leverage on the services AWS will offer from Bahrain, because it is directly flouting the regulation policy from UAE. So if the data service provider will have to cater to this market or a segment of a user who's specific to a region, they will have to go about and set up multiple local installations in each legal region in order to have these local policies adhered to. Now, when we go to the legal front of it, similarly the same case, they will have to have multiple sets of governance policies and data privacy policies established as a fundamental offering, which a lot of service providers now provide along with their ambit of services. Now, when there is a conflict of interest with data privacy being different across different regions, the central model again takes a hit, and they will have to establish this as standalone services in each region in order to cater for this market. So with this, there is an increased cost for installation, increased cost for maintenance. They will have to go about having multiple resources who are trained on this, and they will have to deploy in a massive scale. So by this, the advantages and flexibility that they offer in the market is a little impacted, and the cost benefit that they offer to customers also take a hit, because their own cost goes up, the operation overhead goes up, and this could prove a deterrent for service providers to move into new markets unless they are massive in scale like Amazon, where the cost benefit analysis could prove that them entering into a market in spite of these challenges could prove beneficial. So any small service provider who's providing services endemic to region and not on the big scale will have this kind of challenges prove as a deterrent from entering into new market and catering into a wider segment of consumers. Now we'll move to the other side of the spectrum. We will look at what cloud users will have to look for. We identify three regions of focus. One is data location, pardon me for that, data ownership, and data retention period. Now, as we know, a cloud user, often many times we see that the data is not hosted within their own country. It could be dependent on a technology offering being available only to a particular region, because of which they're utilizing the hosting, storage, and processing capabilities from that region. But under the data localization policy, a cloud user will have to be constantly governed by the data local laws that the data set will be coming under the purview of, and they will have to take stock of this in their consideration before choosing a location on which they can store. They will also have to take user consent if the data localization policy allows them to transfer the data across borders. There should be a definite consent mechanism where the purpose for which the data is transmitted is clearly explained, and also the retention period is defined for that. And data ownership. Now, as we see, a cloud user could have, in the example that we have seen on the previous slides, where the data is stored in another region or a country, there should be a definite division of roles and responsibility identified for each scenario. There should be a matrix which says who the ownership of data always resides with. In majority of the cases, the ownership for the data will reside with the cloud user who's putting up this information as part of his company model. But there are cases where they could leverage on technology developments and services from the cloud service provider, by virtue of which he might get access to partial amount of data or to whatever that service entails. A classic example would be the logging or security event monitoring that service providers offer, for a particular data set. So who does the ownership reside with if the data is being governed by both the user who's storing the data and also the cloud service provider who's offering a service by doing his own analysis and research on top of the data. So a service contract and SLA document will have to be crystal clear to define how the roles and responsibilities are going to be governed by, and there is no ambiguity with respect to any particular case which might arise from a particular business model. And the third most important point, and this is something which is very key to any privacy regulation, whether it is GDPR or any such privacy laws that are prevalent in the world, data retention period. Now, many times a company will collect the data from a citizen of a region or a country, and they would have defined what is the retention period for which the information has to be retained for, and what is the purpose for which they're collecting it. Now, assume that a company is hosting its data on the cloud platform, and for unforeseen circumstances, they will have to shut down their operations and the company no longer exists or ceases to exist. Now, what happens to the data which is put up on the cloud? Many times it just so happens that until the expiry of the contract period, the data is just sitting there on the cloud, and any malicious individual or attacker who wants to do some illicit activity or do a data breach or hack into this information can do so if there is no proper configuration guiding how the safety has to be taken care of. So make sure that you understand what is the retention period. You make sure that as a cloud user, they will have to take stock of how long it's going to be saved, plan for contingencies, and have a clear addressal mechanism how the data should be handled post the expiry of the defined retention period. The data should either be deleted, or if a citizen asks for the information to come back to be removed from the records, it should be addressed in that fashion. And also, if it has to be extended, a proper consent must be taken from these end users. So now we have seen what is the national interest with which countries are operating, what they're trying to protect and why they're trying to protect it, and with localization thrown into the mix, what kind of challenges the service providers face. We will now look at one real life case study which happened in 2016 of August. We all know how LinkedIn operates. So LinkedIn was banned in Russia by a Moscow court. The reason behind this is LinkedIn used the personal information of Russian citizens, and because of their business model, they were not storing this information within the boundaries of the country, because they have a central model in which all the information is thrown open to the other consumers of LinkedIn who want the service to build their own networks. So they argued that LinkedIn, since it's a company which is not set up in Russia, it is registered somewhere else and operating in a global scale, data localization was directly impacting the way in which LinkedIn operated. But Russia has its own data localization policy governing how the personal information of its citizens have to be handled by any service provider operating in the region. This conflict did not have a favorable outcome to LinkedIn. In November 2016, the ban was officially issued and LinkedIn services were not offered to citizens in the country. So this is a case where countries want to protect their own national interests, but service providers who are not adhering to the data localization were not able to build their business model in such a scenario. Now, moving from this, we will also look at some of the countries and their efforts where they proactively go about involving data privacy as a key concern when it comes to the data of the citizens. We'll take two entities, the Dubai International Financial Center, DIFC, and the Dubai Healthcare City, DHCC. Now, these are both entities which handle personal data of citizens, and it could be subjected to penal code prohibition if there is no consent taken from the individuals before disclosure, because they are very sensitive, and this does not govern only the nationals residing in the country, but it also had data of expats or foreign nationals who are working in the country and operating with these entities. So what they have done is they have developed their own regulation in the model of GDPR, in which a clear data protection mechanism was established, and all the service providers or ancillary units who had to comply with them will have to work in a particular model, and they should have a clear demonstration of how the data can be transferred, and they should demonstrate their consent mechanism as well. So this is an effort taken by the country to develop their own way to regulate data privacy for information which is specific to a particular sector. Also, they are also looking at and evaluating how this data that they're collecting can be transferred freely across the country. Now, this is in recognition of the fact that the data is the primary source in which most modern businesses have built upon, and they're leveraging this data source to go on a global scale. China, what it did was, it is through a security assessment, it is identifying the advantages that it would probably get by sharing the personal information and important data belonging to Chinese citizens to outside of China for business model operations. Now, this has been thrown open to public comments, and this shows that countries are now trying to move towards a way in which data localization regulation objectives are met, while the business development can also progress seamlessly in a digitized platform. Now we will move to the recommendation section of our presentation. We have seen what data localization is, we have seen what are the challenges, we have also seen some of the efforts from the countries to bring these concepts together, where data localization, privacy and security objectives and jurisdictional objectives are met, while leveraging the free objectives that a cloud platform provides to companies working in a global scale. Now what we propose in this concept is establishing data embassies. Data embassy setting up is a three-step process according to our recommendation. The first step or the recommendation for this is to establish a central governance council. Now, cloud computing platform today does not have a central governance council like a council for regulations like ISO or PCI. Now, there is no central governance council to regulate how the different practitioners in the market should operate, what will be the rules and frameworks with which each data set will have to be governed and addressed by. So, first idea that we propose is under central governance council is create regional consortiums. By creating a regional consortium, what we are essentially bringing together is a multiple number of stakeholders and industry participants, such as cloud users, cloud consumers. We are talking about regulators, policymakers, industry experts, and businesses which operate in the ecosystem. By bringing them all together, what we are doing is basically identifying what are the factors which are endemic to a region and what should be taken into consideration with respect to data governance on a cloud computing platform. They will be able to identify not only the social and economic factors, they'll also be able to understand the legal factors which will be taken into stock. When we say legal factors, we are talking about the data localization objectives that we have seen in the previous slide. Now, once a regional consortium has identified all of this and has an approach, next step would be to bring all the different regional consortiums together so that they can share their ideas. It will create a forum for knowledge transfer and IP repository. So with this, what you're essentially doing is all the differences which currently exist because of the diversity in the geography or diversity in the policies can be addressed in one central platform. Because right now we don't have a central platform in which all these differences could be brought together for a debate or for a solutioning model, and then identify how do we go about it. So set up regional consortiums for regions, like you set one for APAC, you set one for MENA region, you set one for the US, you set one for all the other regions. Bring them together under the control of a governance council. Now with that, what we will have is one unified body which can identify all the differences which exist in the industry and in the market, and identify a way in which you can address each one. And the objective for this council will be to have a central framework which can govern how data governance will have to be taken care of. Now we'll see an example of how this propagated. There are some countries which have taken the initiative to do this. Post the G20 summit in the US, the Harvard Baker Forum and the New America convened an expert roundtable. Now this forum usually identifies critical and impacting issues which it considers important for the future of the country and what kind of impact these advancements could bring about for its development. So they identified that cloud computing is something which is impactful for the entire globe. And in this roundtable, which was convened on October 3rd, the primary objective or the aim was to chart a path towards global data governance, because they identified that there is no central data governance currently regulating the cloud computing market with respect to data privacy and security. Now, though this objective was not fully met and they could not come up with a global data governance standard from this, what they achieved, however, was they were able to identify the key indicative factors and critical factors which govern how a framework should be developed, and what should be the method of control by which they can define data privacy and data security uniformly across all verticals and across all players, and thereby establishing a seamless way in which data governance can be established as a blanket on cloud computing platforms. So that is our step 2 in establishing data embassies: set up a data governance framework. Now, develop a framework that centralizes data governance for cloud computing. The framework will have to cover and clearly define and state the roles, responsibilities, and accountabilities for all players. It could cover the location in which it is stored. It could cover the data retention period, for how long it can be stored. It would also cover the jurisdictional control which will happen. So a central governance framework which will govern how the data should be regulated on the cloud computing platform. Then there would be a clear guidelines for acceptable usage and best practices. Now, there would be some challenges in having a central framework when we are working in a distributed model like we have seen in the previous slides, and with different countries and entities looking at data governance in a different fashion. There would be some challenges which we will have addressed on the third point of this section. So we'll look at one example of what has transpired in 2019. Following in the G20 summit, following that in June 2019, Japanese Prime Minister Mr. Shinzo Abe launched an initiative called the Osaka Track. Now, the Osaka Track was inspired from the idea of data free flow with trust. They did not want the data sets to be regulated by data localization policies and stored only within the country, because it was impairing the business models which were built on a larger global scale and dependent on a model in which the data can be transmitted freely. So the objective of this initiative was to create a framework to promote cross-border data flows with enhanced protections and safeguards. So what they tried to tell was, do not have a data localization policy which will impair the data flow, but rather identify the data protection methods and safeguards that want to be identified and help promote cross-border data flows. That was the paraphrasing of the idea from Mr. Shinzo Abe. Now, among the 24 countries that sat on the summit, not everybody signed this. Countries like China and United States were ready to sign, and they confirmed their acceptance. But however, there are countries like India, Indonesia, Egypt, and South Africa who did not want to sign this, because there was a question on what kind of protection and safeguards does this framework bring about, and with this protection and safeguard, will their objective that they have established through data localization be met? So this was the reason why there was not an unanimous decision for the idea, though most countries recognize that data will have to flow freely. Their primary objectives of control and privacy and security was still not unambiguously defined for them to go ahead and share their affirmation. So this brings us to the third recommendation, which is setting up of data embassy. Now, what is a data embassy? Now, data embassy is a grouped data center which will have the laws and regulations of the country from where the data originated applicable on top of the data set. So the example that we saw, where a country operating in the Gulf country, in the Middle East or any such region, utilizing the services of hosting from a third country or from Asia, what kind of challenges they face? We found that jurisdictional was one such issue. We find location was one such issue, and so on. So the primary objective of control over privacy was in question there, but the data embassy concept addresses both of this smoothly. We look at a precedent that happened for us to understand how this went about. In 2007, Estonia fell victim to a distributed denial of service attack. we'll have to keep in mind that at this point of time, Estonia had advanced digitally for delivering its services and storing. It had stored all of its citizens' data on the cloud, and what it also did was they were able to bring all their service offerings and key infrastructure services on the cloud platform, and all the citizen needed was a unique identifier, probably an ID, like a passport number or something, which the country identified as a unique way to represent each citizen, and they were able to log into a central umbrella platform from which all the services could be leveraged. Now, with this attack, their data centers were compromised and the data was not available. A number of government and bank websites went offline. Estonia's public sector and data communication networks became inoperable. Thereby, the country was impacted so much from this attack that they could not function in a seamless fashion that they had originally envisioned by moving on to a cloud network. So Estonia came up with a solution for this in 2017. They identified Luxembourg as a country where they wanted to sign a bilateral agreement with. There was a bilateral agreement which was executed. They identified a data center in Luxembourg, enhanced the data privacy and security controls that Estonia wanted to be implemented in this data center. And then they went about moving their Estonian citizens' sensitive data and confidential data onto all of these data centers. Now, by doing this, what they have done is they've created a backup. They've created business continuity so that if in case they undergo an attack again, there will not be a single point of failure, and they can always rely upon backup services to come up and serve the citizens, and thereby the national interests will not be affected in any means. And what they have also achieved is, by virtue of this bilateral agreement, Estonian country retained full jurisdictional control over the data of Estonian citizens. Though the data is being stored in Luxembourg, all the competent judicial authorities and legal regulations that will apply for the governance of data were still maintained by Estonia. Thus, what they have done is all the objectives that a data localization propagates, like control, privacy, jurisdiction, was achieved while still leveraging the advantages of distributed cloud computing platform and on-demand services that they can fall back to. Now, taking a leaf from this, Kingdom of Bahrain in 2018 launched the cloud law. The cloud law was specific for providing cloud computing services to foreign parties. So what happens is, under this article there are two clear definitions. The data stored will be subjected to the domestic law in the foreign state where the relevant consumer resides. So the question of data jurisdiction is handled very clearly. So for a company operating in UAE in the healthcare sector, we'll always make sure that even if the information is stored in the Kingdom of Bahrain, the jurisdictional authorities and control will be retained by UAE, and the data will also be subjected to the jurisdiction of foreign state courts. So what we have achieved here by this law is marry the concept of data localization advantages with what cloud computing platforms seamlessly provide to us by their varied offerings, and this will take away the deterrence that the market is facing currently when individual service providers are unable to develop their business model in such a fashion that they have installations in each legal and jurisdictional region. So by having a central distributed model and protecting the interests of nations and safeguarding their citizens' data, you will provide a seamless environment, and this will ensure that data localization does not become a deterrent for businesses to develop. They can leverage on the technology advancements that they have. They can leverage upon the benefits that cloud computing provides to consumers by having a model in which they can leverage on high flexibility, high scalability, availability, on-demand services. So all of this becomes available to an end user in order to propagate their business model. So we will have a brief summary of what we have seen. We have come to the final section. Data localization is the form in which countries try to protect the data which is sensitive and confidential to them. We are talking about private, confidential and sensitive information or personally identifiable information that a country has recognized as being key for protecting their national interest and for promoting their own national growth. And data localization provides them with set of minimum data privacy and security controls provides them with control over accountability of data, and also provides jurisdictional control to recall the data whenever they see fit and when they analyze the impact of a activity. Now, cloud service providers and cloud users have a shared responsibility and accountability towards data protection towards its end users. We are talking about a model in which there would be shared accountability, whether it comes to data ownership or whether it comes to data compliance and regulation. A lot of service providers offer infrastructure services with all these compliance as a platform. There are a lot of cases where you can, if you are somebody, if it's a company which is operating in the payment sector and wants to comply with PCI DSS, they can host their services on a platform which is already certified for PCI DSS. So the service providers list them on their website as well. So these are facilities that are being offered to enhance the model in which data is being freely transferred. It will also give a comfort for the end users and consumers with respect to the privacy and security in which this data is being treated and handled by various industries in the market. So the recommendations that we have is a three-step process. Establish data embassies through these steps. Establish a central governance council. You go about by setting up regional consortiums for endemic to a particular region. Each consortium will have representatives from the industry and the market providing us with valuable feedback on how it should be addressed and what are the challenges they face. So the Central Governance Council will address all of this and then bring all the regional consortiums together to form this Governance Council, by which we will have a unified approach to govern all the issues faced by various industries and various regions in the world and how they have to be addressed. And the primary objective of this central data governance council will be to find a way in which data governance can be centralized. How we go about it is step number 2. We have a central data governance framework. This framework will be unifiedly applied across all verticals, all industries. Something like what we have seen, either an ISO standard or a PCI standard, which applies across different organizations, verticals, does not depend on the scale of business as well, and is regulated by a central council which takes care of how the framework has to be evolved over a period of time to address all the technology enhancements and the changes in the environment in which it is being assessed. The last step is to marry the concept of advantages of data localization with the benefits that is offered from a cloud platform. How we do about that is establish a network of data embassies. A data embassy is a data center which will allow a country to retain jurisdictional control over the data belonging to its citizens or for the service providers. Thereby, the advantages offered by data localization is preserved, while the cloud users can leverage upon the benefits that are extended by the cloud service providers for the extension of the services across the globe. So there is more maturity that is needed in the data governance process, and we see that it will be a seamless way in which countries can go about and safeguard on the national interest, while businesses can go ahead and leverage the advantages that a cloud computing platform will go about. So cloud service providers will have to adopt the concept of data embassies more, and this will have to be discussed with legal and regulatory bodies and countries for bringing about a unified approach, and that is what we recommend as a solution for this particular case. I'd like to thank Arab Security Conference once again for this opportunity to present amongst you gentlemen. We have some illustrious speakers on the forum where they've talked about interesting topics and current trends. Would love to have met with all the attendees in person. I look forward to next year where we could meet face to face and talk about exchange of ideas and different concepts in the industry at that point of time. Thank you once again for joining us. We'll be available for question and answers now.